Hello, with respect to this honorable call, sir, AO Atubu, my own appearance is for the claimant.
Any appearance for defense?
No appearance.
Yes, Mr. Tubu.
Yes, sir. The matter is selected for adoption of final written address. However, we have a motion, sir. Motion for extension of time. We didn't wish to file in our final written address, sir. It is dated 9th day of January 2024, sir. I was filed on the same day, sir. In the absence of any objection, we move in terms of the motion paper and urging the Honorable Court to grant a release, sir.
This application is not approved. That is clear. Final address of the claimant applicant is taken as unit 5 at set.
As the court pleases.
Yes, Mr. Tubu.
Yes, sir. Our final written address is dated 4th day of January 2024. I was filed on the 9th day of January 2024, sir. We adopt all our written submission as our argument in this matter in urging the Honorable Court to enter judgment in favor of the claimant and grant all the relief sought. That is our humble submission, sir.
Did the defendants file any address?
Sir, no, sir. They didn't. And we served them with our written address, final written address.
You did not defend this suit.
They didn't appear in person since the beginning of this suit, but they filed papers.
Okay.
Yes, sir.
Of the court. The claimant commented by complaint 21 and found in this complaint, the claimant was released from the court. The declaration that the non-payment of salary allows to allow for a month of December 2019 to the 13th day of April 2021 is null and void. And also the these 2, 3, A to E and 4 and in the judgment. The complaint is supported by paper of fact, the case is downloaded document. The complaint was served on December. From the case of the complaint, the defense is capable of defense for the
It's breaking. It's coming remotely.
They should do that picture there.
The 26th day yes, Nigeria, the payment continued to work up to the 8th day of November 2019 when he voluntarily resigned. The letter of resignation was addressed to the first defendant on record. Then, that in accordance with the terms of employment, the chairman said he served the defendant the requisite 1 month notice of voluntary resignation from the employment. Consequent upon which the defendant asked the claimant to stop work, but however refused to discharge to disengage the claimant from their service to disengage the claimant from their services for a period of 18 months before the claimant letter of voluntary resignation was approved. The defendant refused to disengage the claimant from their employment and still fail to pay the salaries for the period. It is the case that after his resignation, the defendant has refused to pay their duty to pay off as required by the terms and conditions of employment. It is his position that the defendant handbook has to provide for other agreed conditions of service that may include those not mentioned in the handbook and that are contained in the employment letter. The claimant has gone on to state in paragraph 11 to 20 of his legal disposition that what he thinks are due to him upon his resignation from the service of the defendant, that it caused his counsel to make a formal demand for the payment of his entitlement with the defendant in law. It is his case that he resigned from the service of the defendant in the 8th day of November 2014. The division was only confirmed on the 13th 2021. The defendant filed a joint statement of defense in this action, along with 2 written depositions. The defense of the defendant was deemed abandoned since they failed to cross-examine the human witness and also failed to enter defense discussion. Issue for determination. From the pleadings and evidence adduced by the claimant in support of his claim before this court, the issue for determination are whether this court is properly considered as regards the parties on the record. If this court finds that this suit is properly considered, court will go ahead to consider issue 2 as formulated below. 1. That is, whether the claimant has offered proof to be entitled to release in this action. The established principle of law on this one now. The established principle of law is that a party to an action must succeed on the strength of his case, not on the weakness of the defense. See the case of Channel Brothers Trading Company Limited against Anton. Citation supply. Their defense to this action was not in any way remove the burden placed on the claimant to prove his case before this court. First, I must start by noting that the claimant was employed by AGS Nigeria Limited as shown on Exhibit C1. The appointment was confirmed by the above mentioned company as shown on Exhibit C2. These 2 documents established without any controversy the existence of a privity of contract between the claimant and the above mentioned company. However, in exiting the contractual relationship, the claimant directed his letter of voluntary resignation in Exhibit C2 to Big Company Limited, the defendant, a different legal entity entirely. The resignation was accepted by the defendant as shown on Exhibit C4. After examining the term of appointment and confirmation of appointment in Exhibit C1 and C2, I cannot find where any reference is made to the claimant serving as a staff of the first defendant. Serving as staff of the first defendant. The claimant also failed in his pleadings to state the connection of the legal nexus between the company and employed him, that is ITS Nigeria Limited, and the present defendant on record, it would have been a very different situation entirely if in instituting this action, company C1 and C2. In the case of Joma Capital Nigeria Limited and others against incorporated trustees of River Park Residence Institution Abuja and others, the court of appeal had this to say concerning the doctrine of duty of contract. As a principle of law, duty of contract postulates the rule that only parties to the contract and should the rule will therefore not allow a stranger to sue or seek to enforce a contract or assume liability or obligation under it because there is law said to exist only between the contracting parties. In this wise, duty of contract uphold sanctity of contract. In the case of Limited against Tripoli Motors, citations of death. Case of Richie against citations of life. Also the case of John Davis Construction Company Limited against Rickles Company Limited and another citations of life. From the authorities consider above, if this claimant intends to sue on the contract of employment evidenced by the C1 and C2, then this action is brought against the wrong party. The effect, therefore, is that this action cannot be sustained against the present defendant on record. In contract, a cause of action can only exist against a person who is a party to the contract. Where a wrong party is sued, no cause of action can be maintained against a person who is not a party to the contract. The implication of this is that the defendant in this suit are improperly joined as parties. The defendants are liable to be struck out as parties to this action, pursuant to are liable to be struck out as parties to this action. Order 13 Rule 14 sub 2 provide that a judge may have I take that again. Order 13 Rule 14 sub Rule 2 of the National Industrial Rules 2017 provides, and I quote, a judge may at any stage of the proceedings, either upon or without the application of either party, and on such terms as may appear to be judged, other than the name of any party or parties improperly joined be struck out. Relying on the more quoted use of this court, it is the order of this court that the defendants in this suit and are hereby struck out as parties to this suit. The other way is this suit without a defendant. The second issue for Abidjan time can therefore not be considered by the court. This suit is hereby struck out for one of proper parties. Parties are to bear their respective course of this action. Judgment is all time.
As the court pleases. Most obliged, sir. Thank you, sir.
Thank you. For the claimant.
Yes, sir.
You brought this suit. You should have joined IGN
yes, sir.
as a party.
Yes, I understand, sir.
Establish a thing between Nigerian movement and Big Polar.
Yes, sir.
But as it is now, I only struck out
yes, sir.
Of the first defendant in this suit as a party.
Yes, sir. Yes, sir.
I'm not shooting the defendant. That does not mean that your cause of action is extinguished.
Okay, sir.
To do this action again and to join the proper parties.
Yes, sir.
Yeah, I didn't dismiss the action. I only consulted the defendant.
Yes, sir.
You have the right to speak the action.
As a couple.
Okay,
very well, sir. Very well, sir. Thank you, sir. Thank you. We appreciate. Yes, sir.
This Sama. So I wish you a counsel.
Thank you, sir. Most obliged, sir. I think we can off it now. Huh? Off it now.
You're right.
Okay.
Yeah, it's not true contract.
Court.
Meeting.
It's a meeting.
The meeting. Thanks. Don't know how to sit from this ritual.
Hmm?
I don't know how to.
Yes.
Yes.
I don't know whether we can exit now.
You can exit.
Or wait till the court rise. Okay, very well, sir. Thank you, sir.
Sir, thank you, my lord.
Thank you, my lord.
Yeah, showed you.
Mhm.
So you have gone out, but
Yes.
I need to go out.
I mean, sir, I have to still go and refine this suit because it was a private company.
Okay.
One other company employed them and gave it to the company they work for.
You exit now, should exit. You exit, leave them.
So they have now removed one. Without the data.
Yes.
Let me see whether it will stop again. Yeah, stop. What? Past 12. Oh, Jesus, this one.
This is caught itself.
What? The thing take that
Data.
the thing take how do they call it? I want to off this speaker. How would I do? Let's go. What? My this thing, what is it called?
Data.
No data. Data is still plenty.
The batteries.
Battery. 33.
Mm-hmm.
So the thing carry the battery like that.
Uh-huh.
Thank God, oh, I charged it in the night yesterday. I think I leave it at 50.
Yeah. Don't do.
They dealt with me, all the lawyers. They dealt with me.
They'll play with you. Don't do anything. Go and do it.
What? I know what you did to me. They'll say, come, I'll come. They refuse to sign. They just do
combo.
I saw my.
No. You have all details. Don't finish. Don't finish. Yeah, contribution. No, wait, don't. What about John? It's outside. John. Ah. You see, I'm not someone, and I won't give her a phone. And I want to give you a phone. Let me look for him. I can't see my return. Let me go to that library side. You want to do something? Okay. Okay.